Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. As always, please like, subscribe, and click the notification bell so you can be updated every time we upload new content. It's our goal to, at the very least, upload new content every day at 8 a.m. Eastern Standard Time. Question number 1. Dooley and Melville were charged with conspiracy to dispose of a stolen diamond necklace. Melville jumped bail and cannot be found. Proceeding to trial against Dooley alone, the prosecutor calls Wixon, Melville's girlfriend, to testify that Melville confided to her that Dooley said, "I still owe him some of the money from selling that necklace." Wixon's testimony is A, admissible as evidence of a statement by a party opponent, Dooley, B, admissible as evidence of a statement against interest by Melville, C, inadmissible because Melville's statement was not in furtherance of the conspiracy, or D, inadmissible because Melville is not shown to have first-hand knowledge that the necklace was in fact stolen. Take 10 seconds. If you chose option B, you'd be correct. Admissible as evidence of a statement against interest by Melville. Hearsay is an out-of-court statement offered for the truth of the matter asserted in that statement. If a defendant is unavailable, the defendant's out-of-court statement that would subject the declarant to criminal liability or would be against the declarant's financial interest is admissible as a statement against interest, hearsay exception. A declarant is considered unavailable if the declarant's attendance cannot be procured by process or other reasonable means. In this case, Melville is unavailable because Melville jumped bail and cannot be found. Melville's out-of-court statement is being offered through Wixon's testimony to prove the truth of the matter asserted in Melville's statement, i.e. that Dooley actually said Melville owed him some money from selling the stolen necklace. Melville's statement not only subjects himself to criminal liability as circumstantial evidence that he sold the stolen necklace, like Dooley said, Melville's statement is also against his own financial interests as circumstantial evidence that he owed Dooley money from selling the stolen diamond necklace, like Dooley said. This means Melville's statement qualifies as a statement against interest hearsay exception. Therefore, Wixon's testimony is admissible as evidence of a statement against interest by Melville. So B would be correct. Question number 2. Miller's department store had experienced a growing incidence of shoplifting. At the store's request, the police concealed Best, a woman who was a detective, at a vantage point above the women's apparel fitting rooms, where she could see into these rooms where customers tried on clothes. Detective Best saw Davis enter a fitting room, stuff a dress into her pocketbook, leave the fitting room, and start for the street door. By prearranged signal, Best notified another police officer near the door who detained Davis as Davis started to go out into the street. Davis was placed under arrest and the dress was retrieved from her purse. Davis is charged with shoplifting. Her motion to prevent the introduction of the dress into evidence will be A, granted because the police should have secured a search warrant to search her bag. B, granted because a customer has a reasonable expectation of privacy while using a department store fitting room. C, denied because the search and seizure were made incident to a valid arrest based on probable cause. Or D, denied because Detective Best could see into the room and thus Davis's activities were legitimately in plain view. Take 10 seconds and choose the best answer now. If you chose option B, granted because a customer has a reasonable expectation of privacy while using a department store fitting room, you'd be correct. The Fourth Amendment prohibits unreasonable searches and seizures. Unreasonable searches and seizures have been deemed to be those involving state action which intrude upon an individual's reasonable expectation of privacy. The Fourth Amendment only applies to publicly paid police and citizens acting at the police direction. In this case, the police concealed Best at a vantage point above the women's apparel fitting room where she saw Davis enter and stuff a dress into her pocketbook. Best was acting at the police's direction, and Davis clearly has a reasonable expectation of privacy while she was in the fitting room of Miller's department store. As such, Davis's motion to suppress the dress should be granted because the search and seizure of the police and Best was unreasonable. Question number 3. Hydro King Inc., a high-volume pleasure boat retailer, entered into a written contract with Zuma, signed by both parties to sell Zuma a powerboat for $12,000. The manufacturer's price of the boat delivered to Hydro King was $9,500. As the contract provided, Zuma paid Hydro King $4,000 in advance and promised to pay the full balance upon delivery of the boat. The contract contained no provision for liquidated damages. Prior to the agreed delivery date, Zuma notified Hydro King that he would be financially unable to conclude the purchase, and Hydro King thereupon resold the same boat that Zuma had ordered to a third person for $12,000 cash. If Zuma sues Hydro King for restitution of the $4,000 advance payment, which of the following should the court decide? A. Zuma's claim should be denied because, as the party is in default, he is deemed to have lost any right to restitution of a benefit conferred on Hydro King. B. Zuma's claim should be denied because, but for his repudiation, Hydro King would have made a profit on 2 boat sales instead of 1. C. Zuma's claim should be upheld in the amount of $4,000 minus the amount of Hydro King's lost profit under its contract to Zuma. Or D. Zuma's claim should be upheld in the amount of $3,500, $4,000 minus $500 as statutory damages under the UCC. Take 10 seconds and choose what you believe to be the best answer now. If you chose option C, you'd be correct. Zuma's claim should be upheld in the amount of $4,000 minus the amount of Hydro King lost profit under its contract. Under the UCC, a buyer's right to restitution after the buyer breaches a contract is offset by the seller's damages suffered as a result of the breach. The provable lost profits for a volume seller is the contract price minus the resale price plus lost profits. Here, Zuma was the party breaching the contract, so Zuma's restitution will be offset by Hydro King's damages suffered as a result of Zuma's breach. Hydro King was likely a volume seller under the UCC, as indicated by Hydro King being a high-volume retailer. This means Hydro King is considered to have been able to make 2 sales had Zuma not breached the contract. So a court will allow Hydro King to recover the lost profit on the lost sale due to Zuma's breach. Hydro King's lost profit from Zuma was $12,000 minus $9,500 equals $2,500. The $2,500 would offset the $4,000 advance payment, leaving Zuma with $1,500. Hydro King will not receive anything else because Hydro King sold the boat to a third person for the same amount it would have sold to Zuma. Accordingly, the court should decide Zuma's claim should be upheld in the amount of $4,000 minus the amount of Hydro King's lost profit under its contract to Zuma. In a civil action for personal injury, Payne alleges that he was beaten up by Dabney during an altercation in a crowded bar. Dabney's defense is that he was not the person who hit Payne. To corroborate his testimony about the cause of his injuries, Payne seeks to introduce, through the hospital records custodian, a notation in a regular medical record made by an emergency room doctor at the hospital where Payne was treated for his injuries. The notation is, patient says he was attacked by Dabney. The notation is A, inadmissible unless the doctor who made the record is present at trial and available for cross-examination. B, inadmissible as hearsay not within any exception. C, admissible as hearsay within the exception for records of regularly conducted activity. Or D, admissible as a statement made for the purpose of medical diagnosis or treatment. Take 10 seconds and choose the best answer now. If you chose option B, inadmissible as hearsay not within any exception, you'd be correct. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay included within hearsay is admissible only if both levels of hearsay satisfy a hearsay exemption or exception. 2 exceptions are tested here. First, the business records exception allows a record of events, conditions, opinions, or diagnoses recorded in a business record to be admitted where the information was recorded by somebody under a duty to record or report such information, by somebody with personal knowledge of the information at or near the time of the matter described. and when the record was kept in the ordinary course of business. Second, a hearsay statement by one person concerning a past or present mental or physical condition or its cause is admissible if made for or pertinent to medical diagnosis or treatment. Here, the first level of hearsay is the medical record, which meets the requirements of the business records exception. The emergency room doctor had a duty to report and had personal knowledge of the conversation, and the medical record is the sort that is regularly kept in the hospital records. The second level of hearsay is Payne's statement that he was attacked by Dabney. Introducing the statement to prove that Payne was actually attacked by Dabney is hearsay, and no exceptions apply. The closest possible exception is a statement made for medical diagnosis or treatment. However, this exception is not satisfied because the identity of Payne's assailant is irrelevant to Payne's past or present mental or physical condition. Therefore, the second level of hearsay does not fall within any exception, and the notation is inadmissible as hearsay. Question number 5. Landco owns and operates a 12-story apartment building containing 72 apartments, 70 of which are rented. Walker has brought an action against Landco alleging that while he was walking along a public sidewalk adjacent to Landco's apartment building, a flower pot fell from above and struck him on the shoulder, causing extensive injuries. The action was to recover damages for those injuries. If Walker proves the foregoing facts and offers no other evidence explaining the accident, will his claim survive a motion for directed verdict offered by the defense? A, yes, because Walker was injured by an artificial condition of the premises while using an adjacent public way. B, yes, because such an accident does not ordinarily happen in the absence of negligence. C, no, if Landco is no better position than Walker to explain the accident. Or D, no, because there is no basis for a reasonable inference that Landco was in fact negligent. Take 10 seconds. Choose the best answer now. If you chose option D, no, because there's no basis for a reasonable inference that Landco wasn't negligent, then you'd be correct. To establish a prima facie case of negligence, the plaintiff must prove a duty, a breach of that duty, causation, and damages. The doctrine of res ipsa loquitur applies when the plaintiff does not have direct evidence of a defendant's negligent conduct. In order for res ipsa loquitur to apply, there must be no direct evidence as to the defendant's precise conduct. The accident must not normally occur without negligence by someone, and the defendant must be the most likely person whose negligence would have caused the accident. In this case, Walker has merely established that Landco owns and operates an apartment building, and that Walker was injured when a flower pot fell from above and struck him on the shoulder. While flower pots do not fall from the sky without negligence by someone, the doctrine of res ipsa loquitur does not apply here because Landco is not the most likely person whose negligence would have caused the accident due to the fact that the 70 of the 72 apartments had been rented. Therefore, Walker's claim will not survive a motion for directed verdict because there is no basis for a reasonable inference that Landco was in fact negligent. Question number 6. Old City police officer shot and killed Jones' friend as he attempted to escape arrest for an armed robbery he had committed. Jones brought suit in federal district court against the Old City Police Department and the city police officers involved, seeking only a judgment declaring unconstitutional the state statute under which the police acted. That newly enacted statute authorized the police to use deadly force when necessary to apprehend a person who has committed a felony. In his suit, Jones alleged that the police would not have killed his friend if the use of deadly force had not been authorized by the statute. The federal district court should A, decide the case on its merits because it raises a substantial federal question. B, dismiss the action because it involves a non-justiciable political question. C, dismiss the action because it does not present a case or controversy. Or D, dismiss the action because the 11th Amendment prohibits federal courts from deciding cases of this type. Take 10 seconds and choose the best answer now. If you chose option C, you'd be correct. Dismiss the action because it does not present a case or controversy. Article 3 of the Constitution grants judicial power to the Supreme Court and such inferior courts that the Congress may establish. The cases and controversies requirements are limits on the federal judicial power. A plaintiff must have appropriate standing to file suit in federal court. Standing generally requires A, an injury, B, causation, and C, redressability. The plaintiff must allege and prove actual or imminent injury that is personally suffered. The Supreme Court has denied standing for general grievances. In this case, the state statute at issue authorizes police to use deadly force when necessary to apprehend a person who has committed a felony. The statute is not causing an actual or imminent injury to Jones since he has not committed a felony, so Jones does not have standing to challenge the constitutionality of the state statute. As such, the federal district court should dismiss the action because it does not present a case or controversy. The fact that Jones's friend was killed does not give Jones the right to bring suit here, nor does standing arise as a result, as Jones is not an appropriate representative of the decedent. Question number 7. Dexter was tried for the homicide of a girl whose strangled body was found beside a remote logging road with her hands taped together. After Dexter offered evidence of alibi, the state calls Wilma to testify that Dexter had taped her hands and tried to strangle her in the same location 2 days before the homicide, but that she escaped. The evidence is A, admissible as tending to show Dexter is the killer, B, admissible as tending to show Dexter's violent nature, C, inadmissible because it is improper character evidence, or D, inadmissible because it is unfairly prejudicial. Take 10 seconds, choose the best answer now. If you chose option A, admissible as tending to show Dexter is the killer, you'd be correct. If specific instances of the defendant's prior bad conduct are being offered to prove anything else that is relevant other than character, then the character evidence rules do not apply and the evidence becomes admissible to prove a mimic fact. Mimic facts are A, motive, B, intent, C, absence of mistake or accident, D, identity, and E, common plan or scheme. To prove identity, evidence of prior misconduct that connects defendant to the crime in question is admissible if it is similar and unique. Here, Wilma's testimony that Dexter had taped her hands and tried to strangle her 2 days before the homicide of a girl who was also strangled with her hands taped together in the same location is offered to prove a mimic fact, i.e., the assailant's identity. The remote location, taped hands, and strangling are similar and unique enough to indicate the same person committed both acts. Accordingly, Wilma's testimony is admissible as tending to show Dexter is in fact the killer. Question number 8. Morton was a general manager and chief executive officer of the Woolen Company, a knitting mill. Morton delegated all operational decisions making to Krause, the supervising manager of the mill. The child labor laws in the jurisdiction provide it is a violation of the law for one to employ a person under the age of 17 years for full-time labor. Without Morton's knowledge, Krause hired a number of 15 and 16-year-olds to work at the mill full-time. He did not ask their ages, and they did not disclose them. Krause could have discovered their ages easily by asking for identification, but he did not do so because he was not aware of the law and believed that company policy was to hire young people. If the statute is interpreted to create strict liability and Krause is charged with violating it, Krause is A, guilty because he should have inquired as to the ages of the children, B, guilty because he hired the children, C, not guilty because in the law, the Woolen Company, not Krause, is the employer of the children, or D, not guilty because he believed he was following company policy and was not aware of the violation. Take 10 seconds. Choose the best answer now. If you chose option B, you'd be correct. Guilty because he hired the children. Remember, this is a strict liability question. He hired the children, hence strict liability. No intent is required for a strict liability offense. Mistake of fact is not a defense for strict liability crimes. Ignorance of the law is in fact also not a defense. Here, Krause thought it was company policy to hire young people, and he was not aware of the law prohibiting the employment of a person under 17 years old full-time. Neither of these facts will absolve Grouse of liability for hiring the underage children in violation of the statute if the statute is interpreted to be a strict liability statute. If interpreted as strict liability, the statute was violated simply by hiring the underage children. Thus, Krause is guilty because he hired the underage children. There's no more logic or no more analysis further needed. Question number 9, almost at the finish line. Owner and planner signed a detailed writing in which planner, a landscape architect, agreed to landscape and replant owner's residential property in accordance with a design prepared by planner and incorporated in the writing. Owner agreed to pay $10,000 for the work upon its completion. Owner's spouse was not a party to the agreement and had no ownership interest in the premises. For this question only, assume the following facts. Shortly before the agreement was signed, owner and planner orally agreed that the writing would not become binding on either party unless owner's spouse should approve the landscaping design. If owner's spouse disapproves the design and owner refuses to allow planner to proceed with the work, is evidence of the oral agreement admissible in planner's action against owner for breach of contract? A, yes, because the oral agreement required approval by a third party. B, yes, because the evidence shows that the writing was intended to take effect only if the approval occurred. C, no, because the parole evidence rule bars evidence of a prior oral agreement, even if the latter is consistent with the terms of a partial integration. Or D, no, because the prior oral agreement contradicted the writing by making the parties' duties conditional. Take 10 seconds. If you chose option B, you'd be correct, yes, because the evidence shows that the writing was intended to take effect only if the approval occurred. The parole evidence rule states that no prior expressions or contemporaneous oral statements are admissible that contradict the final integration between the parties. However, such a prior expression or contemporaneous oral statement are admissible to show the existence of a condition precedent. A condition precedent is a condition that must occur before someone's performance is due. If the condition is not satisfied, non-performance is excused. Here, owner and planner orally agreed that the landscape contract would not become binding on either party unless owner's spouse approved the landscape design. This oral agreement was made shortly before signing the landscape contract and serves as a condition precedent to the landscape contract becoming binding, so it is admissible under the parole evidence rule. Accordingly, evidence of the oral agreement between planner and owner is admissible because the evidence shows the writing was intended to take effect only if the approval occurred. Question number 10, the last question in this grouping. Davidson and Smythe were charged with burglary of a warehouse. They were tried separately. At Davidson's trial, Smythe testified that he saw Davidson commit the burglary. While Smythe is still subject to recall as a witness, Davidson called Smythe's cellmate, Walton, to testify that Smythe said, "I broke into the warehouse alone because Davidson was too drunk to help." This evidence of Smythe's statement is A, admissible as a declaration against penal interest, B, admissible as a prior inconsistent statement, C, inadmissible because it is hearsay not within any exception, or D, inadmissible because the statement is not clearly corroborated. Take 10 seconds. Choose the best answer now. If you chose option B, you'd be correct, and you'd be ending on a very positive note here. Admissible as a prior inconsistent statement. A witness may be impeached with evidence of a prior inconsistent statement to contradict the witness's testimony and undermine their credibility. A prior inconsistent statement is admissible to impeach, but inadmissible to prove the truth because it would be hearsay for that purpose. However, in order to impeach a witness with evidence of a prior inconsistent statement, the witness must be given an opportunity to explain or deny the inconsistency. In this case, Davidson is introducing Walton's testimony to contradict Smythe's testimony that he saw Davidson commit the burglary. As such, Walton's testimony is admissible to impeach Smythe by presenting evidence of Smythe's prior inconsistent statement because Smythe is still subject to recall as a witness. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, as always, we upload content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content. We look forward to seeing you again.